do I have to report to Judge Owsley secondhand information? That's objectable in a trial. He demands that I report information that comes from the Court of Appeals. They're the primary focus. They're the primary target. They're the ones who are creating the information. They've got the first-hand knowledge of how the status is for what they're doing. Yet they keep that. Yet Judge Owsley demands that I, or in my case, my lawyer, reports directly to him. Nothing on paper is satisfactory. We have to go to the courthouse to make that report, and he's demanding secondhand information from my lawyer. My lawyer has to check, and even I do, the Third Circuit with the Third Circuit Court of Appeals, like what, an hour before.
Turn right at the traffic light.
An hour before my lawyer has to check with the Third Circuit Court of Appeal an hour before meeting with Judge Owsley, so he has the most update information. Yet that's something that Judge Owsley could do himself. So demanding secondhand information is once again a fallacy, just like the whole kangaroo court was a big fallacy, relying on circumstantial evidence and not following the constitutional law. And he continues to do it, even with demanding in person of these updates from the third-hand source. My lawyer has to check with the Third Circuit Court of Appeals. It just like everyone else has to. There's a case number. You type it into their system to see what the status is for my case. And yet, Judge Owsley demands my lawyer do that for him. And if he wants to bring this to court with the prosecutor present, well, this is an objectionable demand. It's almost like Judge Owsley is demanding this on behalf of the prosecutor, and because the prosecutor is the one who is supposed to be following through on collecting payments and issuing arrest warrants for lack of payment, lack of punishments, whatever, not following the punishment. Judge Owsley is doing a big step towards helping out the prosecutor. So it's like my lawyer is put in a position to have to like deal with the judge, when really he should be talking more directly with the prosecutor and objecting to the prosecutor demanding. I'd say
right at the stop sign.
I'd say the demand would be more on the prosecutor, the prosecutor's demanding that I show up in person at court to make this report, and I would object to that and argue that he's demanding secondhand information when you could just give them the link. They have, by this has been the second meeting now, the second hearing on the updates, the update hearing. How many courts have update hearings like this? And like you object to that and say, previously we've given you the information for you to go to the website directly and look at that yourself. You have the information, you have the website, you have the court case, and you can look it up yourself, okay? And you would get more accurate information directly from the Third Circuit Court of Appeal than you would my lawyer. Because my lawyer, you know, he might check it an hour before. Something could happen before the hearing. Something could happen between that hour and the hearing in the Third Circuit Court of Appeal. So Judge Owsley is not getting the most up-to-date information by demanding my lawyer drive to his courthouse just to say he has nothing to report from the Third Circuit Court. It's really an inefficient system, and how can we object to that? How can we stop that?